CASEVAULT, the one sentence they never explained. The court document was only one sentence long. No introduction, no explanation, no emotional language. Just a single procedural line filed in a Manhattan courtroom. And yet, that sentence changed the direction of a murder trial that had already shaken New York City to its core. A case involving the killing of a major corporate CEO, a suspect accused of crossing state lines, a defense strategy that could have reduced a murder charge into something far less severe, and then, without warning, it was gone. Withdrawn. Silently. No reason given. No justification offered. And in a courtroom where every word matters. Silence is never neutral. But before that silence, there was chaos. December 2024. New York City. Cold air. Bright lights. Heavy traffic outside a business district in Manhattan. A high-profile executive, Brian Thompson, CEO of United Healthcare, was shot and killed outside a corporate event. The attack was sudden, public, and precise enough to send shockwaves through both corporate America and the legal system. Within hours, the story stopped being local. It became national, and then it became something else entirely. A mystery with political weight, financial implications, and psychological speculation layered on top of a murder investigation. Because investigators quickly realized something unsettling. This did not look random. According to prosecutors, the suspect, Luigi Mangione, was not acting in a moment of uncontrolled rage. They described something more structured, more deliberate. They alleged he tracked movements, documented thoughts, and traveled across multiple states before the killing took place. A pattern, a timeline, a sequence. And in criminal law, sequence is everything. Because sequence implies intent, and intent is what separates murder from everything else. Inside the courtroom, months later, another name remained central to the case. Brian Thompson, a corporate executive whose death had become the center of a legal and media storm. But in court, he was no longer just a victim. He was the anchor point of a narrative prosecutors were building step by step. A narrative that said, this was not an accident. This was not confusion. This was not emotional collapse. This was planning. But then came the defense, and with it, a completely different version of reality. At first, defense attorneys signaled a strategy that changed the entire tone of the case. A mental health-based argument. Not insanity in the traditional dramatic sense, but something more subtle. A claim of severe emotional disturbance at the time of the killing. Under New York law, this matters. Because if a jury accepts extreme emotional disturbance, a murder conviction can be reduced to manslaughter in the first degree. Not freedom, but a drastically reduced sentence. And suddenly, the entire case shifted from one question to another. Not did it happen, but what was happening inside his mind when it did. And that question is where everything began to fracture. Because once mental health enters a murder trial at this level, the entire case changes shape. Psychological evaluations, expert witnesses, confidential reports, private court hearings, and sealed documents that the public never sees. And in this case, that is exactly what happened. Certain records were sealed by the court. Certain discussions were held behind closed doors. And the public was left with fragments of information, but not the full picture. And in true crime cases, fragments are dangerous because people fill in the gaps themselves. Then came the turning point, a quiet procedural update. No press conference, no dramatic announcement. Just a filing submitted to the court, one sentence. The defense was withdrawing its notice of intent to pursue a mental health-based defense. That was it. No explanation, no reasoning, no public clarification. And in legal terms, that is allowed. But in strategic terms, it is highly unusual because mental health defenses are not casual decisions. They require months of psychiatric evaluation, expert coordination, legal risk assessment. And once announced, they are rarely abandoned without a very specific reason. So the question immediately emerged. What changed? Inside legal analysis circles, 3 possibilities began circulating. The first, the evidence did not support the claim. The second, the defense risked exposing more damaging material if they continued. The third, and most unsettling, that something in the sealed evaluations made the strategy unusable. Not weak, unusable. And that distinction matters. Because in criminal defense law, abandoning a strategy is not just about weakness. It can be about danger. Sometimes introducing a mental health defense opens the door for prosecutors to bring in psychological evidence that would otherwise remain restricted. Evidence that could reinforce intent rather than diminish it. Evidence that could harden a jury's perception instead of softening it. And once that door opens, it cannot be closed again. Meanwhile, prosecutors held firm. Their narrative did not shift. They continued to argue that Mangione's actions were deliberate, structured, and supported by alleged writings and behavioral documentation collected during the investigation. They emphasize planning. They emphasize travel. They emphasize continuity, because continuity is the foundation of premeditation. And premeditation is the foundation of first-degree murder. But the defense withdrawal created a vacuum. And vacuums in high-profile cases never stay empty. They fill with speculation. Online forums exploded. Legal commentators debated interpretations. News analysts revisited earlier filings. And the same questions repeated everywhere. Was there a psychological report that contradicted the defense? Did expert witnesses refuse to support the argument? Or did something emerge that would have made the defense position worse if introduced in court? No one could answer, because the records remained sealed, and the court did not comment. Then came another judicial decision. The sealed materials would remain sealed, even after the defense abandoned the mental health strategy. That decision intensified scrutiny. Because in most cases, once a defense is withdrawn, related confidential materials lose urgency. But not here. Here the seal remained. And that suggests something important. Whatever's inside those documents is still considered sensitive enough to protect, even when the strategy they were tied to no longer exists. Inside courtroom strategy analysis, another interpretation began to take hold. The withdrawal was not confusion. It was control, a recalibration of defense strategy away from a potentially risky psychological argument and back toward a narrower legal question, intent. Because once mental health is removed from the equation, everything returns to a single point. Did he intend to do it? Or is there reasonable doubt about his state of mind without formal psychiatric framing? That is a very different trial, and a much more controlled one. But the public still returned to the same unanswered mystery. Why withdraw a defense that could reduce a murder charge? Why do it silently? Why do it without explanation? And why does the court still keep related materials sealed? Each question leads to another, and none lead to clarity. And that is what makes this case different. Not just the crime, not just the suspect, but the structure of what is missing. Because sometimes, in criminal trials, what is removed from the narrative becomes more important than what remains. The trial has not even reached its final phase yet. Jury selection still looms. Opening statements have not fully unfolded. Expert testimony has not been presented in full public view. And the core battle between prosecution and defense is still ahead. But something fundamental has already changed. Not in evidence, not in testimony, but in strategy. A defense that was once central is gone, and no one has said why. And so the case now sits in an unusual state of tension. The prosecution continues forward with a theory built on planning and intent. The defense moves forward without its most controversial psychological argument. And the public is left with sealed records, silent filings, and unanswered questions. Because in the end, this case is not only about what happened in Manhattan that day in December 2024. It is about everything that followed. The decisions made in courtrooms. The strategies changed behind closed doors. The documents that remain hidden, and the single sentence that quietly reshaped a murder trial without ever explaining itself. And as the trial approaches its next phase, one question remains at the center of everything. What was strong enough to be proposed as a defense, but too dangerous to keep in court? And for now, that question remains unanswered, still sealed, still silent, still waiting.